The Supreme Court of the United States dropped a 7-2 ruling on June 1st, and most Americans woke up completely unaware that something significant had just shifted in the balance of power across this country. Think about that for a moment. 7 of the 9 most powerful judges in America issued one of the most consequential structural rulings in a generation, and it barely led the morning news. It got buried under celebrity drama, political shouting matches, and the usual cycle of manufactured outrage. But make no mistake, what happened on June 1st may end up affecting every single one of your 50 states, and the reason why is far bigger than one court case. This wasn't some minor procedural tweak. This wasn't lawyers quietly arguing over a technicality. This was the Supreme Court addressing one of the most abused legal weapons in modern American politics, nationwide injunctions, those sweeping court orders that allowed a single federal judge in one random courtroom to freeze laws and policies for all 330 million Americans at once. And with a decisive 7-2 ruling, 7 justices looked at that system and said, enough. I'm going to break down exactly what happened, why it happened, who's reacting right now, and what this means for your state, your community, and your future. This is the kind of ruling that doesn't stay trapped inside a law library. It reaches into every state capital, every governor's mansion, and eventually into the everyday lives of ordinary Americans. And if you're tired of important stories disappearing under the noise, stay with me all the way through. Before we get into the details, there is something important you need to understand. Whenever a major Supreme Court decision comes down, people immediately rush to explain what it means. Politicians explain it, activists explain it, media outlets explain it, but often the people doing the explaining are also the people who benefited from the system before the ruling changed it. That doesn't automatically make them wrong, but it does mean you should listen carefully, because when power shifts, the people who were comfortable with the old arrangement rarely volunteer to explain why the change matters. That is exactly why this story deserves a closer look. To understand why legal experts reacted so strongly, you first need to understand something that rarely gets discussed outside constitutional law classrooms. Here's the thing about nationwide injunctions that official Washington spent years pretending wasn't a problem. They became a loaded weapon, not a legitimate legal tool, a partisan bypass around democracy itself. The mechanics were breathtakingly simple. You lose in Congress, you lose at the ballot box, the voters don't give you what you want. So instead of accepting the result and doing the hard work of persuasion, you go judge shopping. You find the most sympathetic federal district court judge in the country, maybe in California, maybe in Texas, maybe in Hawaii, and you file a lawsuit. Then, with the stroke of one pen, that single unelected judge can issue a nationwide injunction that stops a president's executive order, blocks a state law, or freezes a federal regulation for every single person in America. That is not how the Constitution was designed. The founders never intended one judge in one corner of the country to act like a national super-legislator. But for years, both parties happily abused this power whenever it suited them. It was convenient, it was effective, and it was absolutely corrosive to self-government. This practice exploded in recent decades. Under one administration, attorneys general and activists used nationwide injunctions to block travel bans, immigration policies, and border security measures almost immediately after they were announced. Under the next administration, states fired back with their own nationwide injunctions against student loan policies, climate regulations, and enforcement priorities. The result was legal whiplash, policy chaos, and a growing sense that real power in America had quietly shifted from elected leaders to district court judges who never had to face a single voter. The Supreme Court had been warning about this problem for years. In earlier decisions, the justices had started sketching limits around these sweeping orders, but the lower courts kept doing it anyway. The abuse continued. The pattern became normalized until June 1st. In the weeks leading up to this emergency ruling, multiple states had filed serious constitutional challenges against what they described as a pattern of federal overreach. These weren't fringe complaints. Sitting governors, state attorneys general, and entire legislatures argued that federal agencies were issuing rules that effectively rewrote state laws without any real democratic process. They claimed executive actions were being used to bypass Congress and crush state authority. Instead of addressing those concerns on the merits, lower federal courts responded the same way they always do, with the very weapon the states were complaining about. They issued nationwide injunctions blocking state laws before they could even take effect. Let that sink in. States went to court saying the federal government is overstepping, and the federal judiciary answered by using nationwide injunctions to neutralize democratic decisions made by those same states. The lower courts weren't acting as neutral arbiters. They had become an extension of whichever political side happened to be filing the lawsuit. The Supreme Court saw the pattern clearly. That's why they acted quickly. That's why it came as an emergency order. 7 justices, crossing ideological lines in a 7-2 decision, decided the time for gentle signals was over. What's especially remarkable is not simply that the court ruled. Courts issue rulings all the time. What's remarkable is the vote itself, 7-2. In today's political environment, where Americans are constantly told that every institution is deeply divided along partisan lines, A 7-2 ruling immediately demands attention. Decisions with margins that large often signal something important. They suggest that justices with different legal philosophies, appointed by different presidents, and often viewed as ideological opponents, looked at the same constitutional question and reached the same conclusion. That does not happen every day, and when it does happen, people who follow the court closely pay very close attention. Justice Neil Gorsuch, in a powerful concurring opinion, delivered one of the most important lines of the year. He argued that lower federal courts issuing these broad injunctions had been acting like unelected, unaccountable national policymakers rather than judges applying the law to the specific parties before them. Gorsuch reminded everyone of the core principle of equitable relief. A court's remedy should match the actual injury suffered by the actual plaintiffs in the case. Not imaginary harms to millions of people who never appeared in court, not national policy changes driven by whoever filed the lawsuit in the most convenient jurisdiction. Justice Sonia Sotomayor, writing for the two dissenters, raised a legitimate practical concern. She worried that limiting nationwide injunctions could create a patchwork of laws, where the same federal regulation might apply differently across states depending on who won which lawsuit in which court. Those were serious arguments made by an experienced jurist viewing the issue through a different but genuinely important lens. The majority acknowledged that concern but responded with a harder truth. The old system didn't solve inequality. It just moved it. Instead of consistent law, the country got consistent judge shopping. The side with better lawyers, more money, and the right zip code got to set national policy. That isn't justice. That's power disguised as law. The Supreme Court chose the more difficult but more honest path. The majority made it clear throughout its reasoning that constitutional convenience is not the same thing as constitutional authority. Just because something is efficient does not automatically make it lawful. Just because something achieves a desired policy outcome does not automatically place it within constitutional boundaries. And just because officials believe they are pursuing worthy goals does not mean constitutional limits suddenly disappear. Those ideas sound simple, but they strike at the center of countless legal and political disputes currently unfolding throughout America. The ruling didn't completely eliminate nationwide injunctions, but it placed strict new limits on them. Going forward, remedies must generally be limited to the parties before the court unless there are truly extraordinary circumstances. This returns power to the states and forces everyone back toward the harder but more legitimate path of elections, legislation, and genuine democratic accountability. Now let's talk about what this actually means for your state, because this ruling didn't just change legal procedure. It rewrote the power map for all 50 states overnight. Start with immigration, one of the most explosive battlegrounds of the last decade. For years, nationwide injunctions turned border policy into a game of legal ping pong. When certain states tried to enforce stricter immigration measures, a single judge in a distant state could freeze those policies for the entire country. When administrations tried to reshape enforcement priorities, opposing states hit back with their own nationwide blocks. That whiplash just became much harder to execute. States can now implement policies with far more confidence that one activist judge won't shut down the entire operation from thousands of miles away. The Supreme Court basically told lower courts, you don't get to run national immigration policy from the bench anymore. That power belongs back with elected officials and the democratic process. Election law is perhaps the most politically explosive area this ruling touches. Voter identification requirements, absentee ballot rules, early voting windows, mail-in deadlines, redistricting maps, these have all been favorite targets for nationwide injunctions. In every major election cycle, whichever side felt threatened would rush to court seeking a national block. One judge could rewrite election rules for the entire country just weeks before voters went to the polls. That weapon has now been heavily restricted. Election policy returns to where it belongs: state legislatures, state courts, and ultimately the voters of each state. Pennsylvania's rules don't have to be held hostage by a judge in Oregon. Georgia's election procedures won't automatically get frozen by litigation filed in New York. This should reduce the last-minute legal chaos that has become routine in recent election cycles. Environmental policy could experience some of the most profound long-term consequences. The Clean Power Plan, methane regulations, EPA water rules, endangered species designations, many of these have swung wildly back and forth depending on which party controlled Washington, often halted or restored by nationwide injunctions from the opposing side. Environmental groups and industry alike have relied heavily on friendly district courts to impose or block national standards when Congress wouldn't act. With the Supreme Court's new limits, that strategy becomes significantly riskier. States will have more power to set their own environmental priorities. The fights will still happen, but they'll happen where they should, through legislation, public debate, and accountability to local voters, rather than emergency court orders from convenient jurisdictions. Public safety, healthcare regulations, and education policies all follow the same pattern. Each of these areas has seen waves of nationwide injunctions used as political weapons by both parties for years. The June 1st ruling doesn't eliminate those fights. It redirects them. It forces them back into the democratic arena where they were always supposed to be resolved. That's what makes the 7-2 ruling so remarkable. It didn't favor one political party. It favored the constitutional design itself, and the political fallout is unfolding in real time. Both parties played this game for years and both benefited from it at different moments. When one party held power in Washington, the other party's state attorneys general weaponized nationwide injunctions to block their policies. When the situation reversed, so did the strategy. Each side screamed about judicial activism only when they were on the receiving end. Each side praised constitutional principle only when the injunction was working in their favor. The Supreme Court just closed that revolving door for everyone. This is why reactions have been so intense. Supporters immediately described the decision as a necessary correction, a restoration of constitutional balance that had become increasingly blurred over time. In their view, the ruling reinforced limits that governments naturally resist and safeguards that exist precisely because concentrated power produces unintended consequences. Critics raised serious practical concerns about fragmentation, inconsistency, and the real-world challenges of navigating a more complicated legal landscape. These were not trivial arguments. They were genuine competing visions of how constitutional governance should function in a modern, complex society. Within hours of the June 1st ruling, legal teams in multiple states were already reviewing ongoing litigation to determine how the decision might affect their positions. Attorneys were examining existing cases. Advocacy groups were reassessing legal strategies. Federal agencies were analyzing potential implications from the opposite direction. Everyone recognized the same reality. The decision resolved one dispute while opening the door to many new ones. That is often how major Supreme Court rulings work. They answer one question while creating several others. They settle one conflict while reshaping the terrain for future conflicts. For the ordinary American trying to make sense of all this, here is what matters most. Your state just got more power back. Whether you live in California or Texas, New York or Florida, Ohio or Georgia, your elected leaders now have greater ability to actually govern according to the values and priorities of your state's voters. That means more policy experimentation, more diversity across states, and more direct accountability. It will be messier. Some states will make choices you strongly disagree with. Results will sometimes be slower and harder to achieve. But this is what self-government actually looks like. It demands more from all of us. It requires citizens to pay attention to state elections, to engage with local representatives, and to stop outsourcing the hardest political questions to distant courtrooms. The deeper message buried inside the court's reasoning is one that political leaders in Washington have not wanted to hear for a long time. Do the work. Build consensus. Pass legislation. Convince the public. Win elections. Govern through the constitutional process rather than searching for shortcuts around it. Shortcuts are attractive. They save time. They avoid messy compromise. They produce faster results. But constitutional systems were intentionally designed to make major changes difficult. The founders understood that concentrated power produces unintended consequences. They believed dividing authority created frustration, but also protection. The June 1st ruling appears deeply rooted in that same philosophy. The immediate legal impact is still being fully evaluated. Lower courts must now interpret and apply the Supreme Court's reasoning to cases already in progress. Future disputes will test the boundaries of this ruling. Different appellate courts may reach different conclusions in the short term. Additional cases will almost certainly work their way back to the Supreme Court in the years ahead. This was an emergency order, not a final comprehensive decision resolving every detail. The underlying legal battles continue, but one thing will not return to the way it was. The casual, reflexive use of nationwide injunctions as a routine political weapon is now severely restricted. Lawyers, advocacy groups, federal agencies, and state governments are all recalculating their strategies. The entire game has changed. Constitutional decisions rarely remain confined to legal textbooks. They eventually affect policy, they affect regulations, they affect enforcement decisions, they affect what governments can and cannot do. And when those changes work their way through the system, the effects spread far beyond the courtroom. Some of those consequences will emerge quickly. Others may take years to fully develop. Future administrations will confront them. Future governors will confront them. Future courts will confront them. And ultimately, voters across all 50 states will confront them. The ultimate significance of this ruling may not become fully apparent until long after today's political debates have faded from memory. History often works that way. The most important decisions are not always the ones generating the loudest headlines. Sometimes they are the decisions that quietly alter the rules governing everything that follows. They don't announce themselves with breaking news banners. They simply change the ground beneath your feet, and you only understand the full weight of that shift years later when you look back and trace where things began to move differently. That possibility is exactly why legal experts have been paying such close attention since June 1st, because they understand something many Americans are only beginning to recognize. This may not be the end of a constitutional debate. It may be the beginning of a new one. 7 justices looked at a pattern that had been building for years and decided it could no longer continue unchanged. They drew a line. Now the country must decide what happens next. State governments will respond, federal agencies will respond, political leaders will respond, courts across the nation will respond, and ultimately the American people will respond. That is how constitutional systems evolve, not through one decision alone, but through the reactions that follow, the cases that build on it, and the democratic choices that citizens make when power is returned to them rather than concentrated in a single courtroom. The establishment media barely covered this story. It disappeared under the usual noise because it doesn't fit a simple partisan narrative. But you now understand the full weight of what happened on June 1st. Every one of the 50 states was affected by this ruling. The power balance between Washington and the states just shifted. The era of one-judge national vetoes is severely restricted. Self-government is not easy. It never has been. It demands engagement, patience, and a willingness to do the hard work of democracy, even when shortcuts are available. But it remains the most important political experiment in human history. The Supreme Court did its part on June 1st. The rest is up to elected officials, state governments, and most importantly, the citizens who will decide whether to rise to this moment with genuine engagement or keep hoping someone else handles it. The ground shifted beneath all 50 states. The debates are only beginning. The legal battles are only beginning. And the consequences may extend far beyond anything most Americans currently realize. Which policy area do you think will be most dramatically transformed? Immigration, elections, environmental policy, public safety, or something else entirely? Drop your thoughts in the comments below, and if you believe important stories like this one deserve clear, honest explanations, make sure you subscribe. Because the developments that shape your future are often the ones that receive the least attention, and this story is far from over.